Good afternoon. Mr. Luckman and I welcome you to another discussion of the great ideas. Today, we're going to consider justice in relation to law. I'm sure you realize that we cannot cover the whole subject of justice. Nevertheless, even though we're going to consider justice only in relation to law, the application of laws, the making of laws, and justice in the very substance of law, it may be useful to try to answer the general question, what is justice? Now, most people run away from that question, just as they run away from the question, what is truth? Like Pontius Pilate, they think they don't have time to wait for the answer. But Pilate was wrong, and so are all those others wrong who think that it is difficult to answer the question, what is justice or what is truth? Neither of those questions is the hard one. The hard question is, what is true in this particular case? Is this statement true or false? Or is this law just or unjust? That's a hard question. But the question, what is justice, I think we can answer quickly. The most famous answer to the question, what is justice, has been given by a Roman emperor, or by those who wrote a book for him. The emperor is Justinian. We have a plaque here on the wall which shows the picture of Justinian, and in that picture you see not only the Emperor Justinian himself, but also his court and the Archbishop of Ravenna. Underneath the picture of Justinian is the famous definition of justice. Justice, it says, is the earnest and constant will to render every man his due. Now, I have here the Institutes of Justinian, the book that Justinian caused to be compiled by the great jurists of Rome. It supposedly is a compilation of all the Roman law, and that sentence I just read is the opening sentence of Book 1. I like this translation a little better. Justice is the constant and perpetual will to render to each man what is his own. Is that the definition of what justice is? Only in part. The other part of the definition of justice is in terms of the principle of equality. Justice consists in treating equals equally and treating unequals in proportion to their inequality. Everyone understands this, I think. Certainly most parents do in relation to their children, and most children in relation to their parents. In a family, for example, in which there are two children, it's perfectly clear, is it not, that if one child does something and gets punished in a certain way, justice requires that if the other child does the same thing, the other child should be punished in exactly the same way. And if the parent doesn't do that, the child at once cries out against injustice. Or the other kind of justice in the family is allowing one child to stay up later than another, if that child is older than the other. Or if two children of unequal age, giving one a smaller allowance, the younger a smaller allowance, and the older a greater allowance. This is justice, rendering to unequals something in proportion to their inequality. You see what I mean when I say that in this basic sense, everyone knows what justice is. Certainly all children know what justice is.
No, I'll agree that children know what justice is, just as you've explained it. And I'm sure that some adults do too, particularly those adults who haven't been to college and told by their professors that it's impossible to know what justice is or to define it. But nevertheless, I think you'll agree with me that this relationship of justice to law is not a simple matter. It's a very difficult question. And it brings to my mind here, and your attention, the question you may remember we received from Mrs. Nino Gutadaro.
Yes, I do remember, Lloyd.
She lives in Palo Alto and wrote you this question. How can anyone say that law is justice? To my way of thinking, bad or unfair laws can be and are made. Therefore, I maintain that law should be measured by justice. What's your viewpoint on this question?
My viewpoint, Mrs. Gutadaro, is the same as yours. Namely, that law should be measured by justice, not that law is justice. But I am compelled to tell you that others disagree with us. There is an opposite viewpoint, one quite opposed to this that you and I share. So let's begin by facing this basic issue about the relation of law and justice. Let me go to the blackboard and state, first of all, the opposite point of view, the one which says that law is justice, or that law is the measure of justice. This is the view held by those who regard law as the expression of the sovereign will, or as that which pleases the prince and as having no relation to natural law. According to this view, laws are the measure of justice in human acts. Human acts are just or unjust according as they conform to what the laws in a particular land are. And according to this view, the things which men do that are wrong are all called, as the lawyers say, mala, using the Latin here, mala prohibita, or wrongs which are wrong only because the law prohibits them. According to this view, then, murder is just like driving on the left side of the street. Murder is wrong because there's a law against murder. Driving on the left side of the street is wrong because there's a law against driving on the left side of the street. And if there were no law against murder and no law against driving on the left side of the street, neither would be wrong. Both are wrongs on the same plane, wrongs made by the fact that some state prohibits that as a matter of law. Now, the opposite point of view, the one that I hold, and the one that I gather you hold, Mrs. Goodadoro, and others, all those, for example, who think that the law is grounded in reason and that it is ultimately derived from the natural law, those who hold this view think that justice is above law and is the measure of law, and that as justice measures laws, the laws in turn become just or unjust. Some laws conform to the principles of justice, and some laws do not, and they're the unjust laws. In other words, the second point of view adds something to the picture. It says that there's justice above laws, and it is the principle of justice which determines which laws are just and which are unjust. And in consequence of that addition, something is changed in the picture. Let me add the words here. Mala, the Latin words mala per se, meaning not wrongs merely prohibited, but wrongs in themselves. According to this second point of view, there are two kinds of wrongs. Wrongs like driving on the left side of the street, which means a wrong act because the law prohibits it, and things like murder, which is not merely a wrong due to the prohibition of the law, but wrong intrinsically, wrong according to the very nature of justice. Moreover, according to these 2 points of view about law in relation to justice, the first one denies natural rights. All human rights are legal rights, granted by the state and capable of being taken away by the state. But according to the second view, the view that justice is the measure of law, there are over and above legal rights, inherent and unalienable natural rights. Now, I should like to proceed this afternoon on the second point of view, the point of view which says that justice is the standard or measure of law and determines which laws are just and which are unjust. And I'd like to proceed in 3 different connections. I'd like first to consider the application of law, the administration of laws by courts of justice. And second, to consider justice in the making of laws. And third, to consider justice in the very substance, in the very content of laws themselves. Now, let me begin by considering justice in the application of law. As courts decide cases and apply laws to particular cases, what is justice? I think we all know what justice is in this connection. Justice consists in fairness and equality, treating all men alike, respecting no persons over other persons, no favoritism, acknowledging no privileged classes before the law. You all remember, I think, or know the words that are engraved in stone on the top of the United States Supreme Court. It says, equal justice under laws. That means that all men come before the law as equals to be treated equally. This is justice in the administration of law. Another way of remembering this is to remember the statue of justice, of blind justice holding the sword and the scales. If you don't remember the statue, let me show you a picture of legal justice, a painting that hangs on the walls of the state capitol of Pennsylvania. There you see another representation of legal justice. I had an artist make a drawing of that picture so that you could see the elements more plainly. Look at this representation of it now, please. Here in this representation, you can see the scales in the hands of justice, the sword, and the blindfold on the eyes. Let me talk briefly about those three symbols. The scales in the hands of justice represents or symbolizes the principle of equality, of a balance. The sword represents the coercive force of the law in the application of justice. And the blindfold on the eyes of justice is most important of all. For the blindfold represents the impartiality of legal justice, the treating of all men alike. It is this fact of the impartiality of justice which gives us the principle that no man shall be a judge in his own case, for no one can be impartial in his own case. No one can be blind in his own case in the application of justice. And that principle has a great deal of relevance to a forthcoming special investigation of a well-known special investigator. Now let me go to the second point we want to take up. Justice in the making of laws. And here, the principle is that the law is justly made if it is made by the right person, in the right way, and for the right end. What is the right end of making laws? The common good, not the private interest of any person. Who is the right maker of the law? We've answered that before. Either the whole people or their duly constituted representatives. In other words, the law to be rightly made must be made by duly constituted authorities. And how shall the law be rightly made? In what manner is the manner of right making? It is that it be done by due process of law, or within the authority and power granted the lawmaker by the Constitution. In this sense, you can see that in our government, at least, in any government that's constitutional, the constitutionality of a law is almost the same as saying the justice of a law. It is rightly made if it is constitutionally made. If it is unconstitutional, it is almost an illegal law or an unjust law. By the way, Lord, this reminds me of a very good question on this very point, I think, that we received from Mr. Willard Knott. Did we not?
Yes, indeed we did, but it's a very long question. Would you like me just to read the parts that I think are relevant?
Please do. I think that will help us considerably.
Well, Mr. Willard M. Knott writes you, begins by saying, as I understand what you have said, law is a code of human behavior having coercive force, which is established for the common good by the majority of the people or by their duly qualified representatives. And I think that is your definition.
Yes, indeed.
It would not appear, rather it would appear to me, Mr. Mott says, that under this definition, without further qualification, the Jim Crow laws of the southern states are then entirely in order. The whites are in the majority, and these laws are a direct expression of what they feel serves the common good. Now, before you answer that, Mr. Knott goes on to suggest that something else must be considered, namely man's natural and unalienable rights. And he says there are rights in an absolute sense, which cannot be subrogated by vote or by force. If a law originating in any fashion attempts to cancel these rights or infringe on them, then that law itself becomes unjust, even though it may have been passed by a majority vote. To which comment he adds, I feel that the concept of absolute human rights imposing limitations on man-made law is one of the fundamental secrets of the success of our American experiment, even though we have not always followed this principle as well as we should. And that's what I'd like you to consider at this point.
Let me correct you just on one point, Mr. Knott. In our definition of law, we spoke of law as being made by the whole people or by their representatives. There was no reference as such to majority rule. Apart from that, however, it seems to me, Mr. Knott, you are in very solid ground. A law can be rightly made by the right persons and in the right manner even. If majority rule happens to be the way in which the delegates or the representatives act, then that is the right manner, it's the constitutional manner. And such a law, though constitutionally made, can still be, as you point out, unjust in substance because it violates some intrinsic, as you say, inherent or inalienable natural right. Of course, in that case, Mr. Knott, if it violates a natural right, the law will not be for the common good. When it's against the natural rights of man, when it's not in conformity with natural justice, law will also be against the common good. Mr. Knott's question, seems to me, Lloyd, leads us to our last point about the justice of laws, the standards by which we determine whether they are just or unjust in substance. Before I go on to that last point, however, I want to go back to something I said earlier, talking about the application of law. We said that laws had to be applied justly and fairly to cases, but there is one problem in the application of law that I meant to talk about that I forgot a moment ago. There is the problem of equity. It is often said that strict justice in the application of law, applying the law strictly to the case, can work greater injustice than not applying it at all. The point is that sometimes laws being general don't apply to all cases equally. And it's important to distinguish this case from that, and sometimes, as the saying goes, to dispense justice by not applying the law to the case. The most famous statement on this, by the way, one that all lawyers know and that all students of the subject study, is in Aristotle's Ethics, in the book on justice, the famous chapter on equity, in which Aristotle says, the equitable is just, but not legally just, but rather a correction of legal justice. The reason, he says, is that all law is universal, but about some things it is not possible to make a universal statement which shall be correct. In those cases, then, in which it is necessary to speak universally, but not possible to do so correctly, the law takes the usual case, though it is not ignorant of the possibility of error. So that when the law speaks universally, and the cases arise on it which is not covered by the universal statement, then, says Aristotle, it is right where the legislator has failed us and has made an error by being oversimple to correct the omission. That is, to say what the legislator himself would have said had he been present in the face of this very case, and would have put the law that way if he had known it. Hence, says Aristotle, the equitable is just and better than one kind of justice, not better than absolute justice, but better than the error which would arise from the absoluteness of applying justice in this case. This is the nature of the equitable, a correction of the law where it is defective because of its generality. Now let me pick up once more what Mr. Knott took us, the problem of justice in the very substance of laws. Here, the standard is twofold. First of all, there is the standard of fairness in the very wording of the law, in the very formulation of the law. And secondly, the standard of natural rights, that the law should conform to natural rights. Let me illustrate the first of these two standards. Suppose for a moment that our penal laws punished lighter crimes more severely and more serious crimes in a lighter manner. Or suppose that two crimes, one of which was a slight crime and one which was a very grave and serious offense, were both punished in the same way. Everyone, I think, would recognize the injustice of such a law in content. It is just only if proportionate punishments are given to the unequal gravity of the offense. Or consider for a moment the matter of taxation. The income tax law, the graduated income tax law, we regard as more just than a flat income tax because we tend to think that those of greater wealth are in better position and should be in the position to pay higher taxes than those of much smaller incomes. So the proportioning of taxation, of the amount of taxation to the amount of wealth, we regard as a just legal regulation. Or consider the matter of military service. Here we regard equality, simple equality, that all young men of a certain age shall be treated alike with respect to the demands the country make upon them, so far as military service is concerned. These are examples of a proportionate distribution of rewards and punishments, or an equal or proportionate distribution of burdens. This kind of distribution of burdens, equal or proportionate, is required if the laws are to be just in their very substance. Now, the other principle here, the other standard for measuring the justice of laws is that provided by natural rights. When laws violate inherent natural rights, they are unjust. For example, the law mentioned by Mr. Nutt, the Jim Crow law in the South, violates the natural right of every man to equality of treatment as far as public conveyances are concerned. Violates every man's natural right to be treated as a human being, as a human person, having the same dignity as every other person. So, at times when laws permitted slavery, they were unjust because they violated the natural right that every man has to be treated as a free man. And before certain amendments were made on suffrage in this country, when there was a restricted franchise, when women, for example, were disfranchised, that legal regulation was unjust. At times in the past, when labor unions were prohibited by law, or collective bargaining was regarded as illegal, those laws were unjust because men have the right, the natural right, to associate in the pursuit of their the activities of labor and to bargain collectively. These natural rights are what determine the injustice of earlier regulations against such acts on the part of working men. Now, insofar as our Constitution accepts almost as its foundation the existence of natural rights, insofar, as a matter of fact, our Constitution in its Bill of Rights actually declares certain of these natural rights, it would be true to say that a law which violated natural rights would be an unconstitutional law. In this case, the unconstitutionality of a law would be almost equivalent to its injustice. But it would be an error to suppose that, let that lead you to suppose that constitutionality of a law, the constitutionality of a law and its justice are one and the same thing. The reason why that would be an error is that constitutions themselves can be unjust. They are, after all, human law too. And constitutions themselves can be unjust, as our Constitution. The Constitution of the United States was unjust before, for example, the Civil War amendments, or as recently as until the time of the woman suffrage amendment, when half the population who deserved to be treated as citizens were then, for the first time, given the franchise and their just status as full citizens in the democracy. This, of course, raises the whole question about the change and improvement in law. It raises the question about how human laws, constitutions, or other positive laws progressively become better and better expressions of justice by conforming more and more to the whole body of natural rights and to the principles of natural justice.
Now, this question that you're raising, pointing out the progress of laws and their greater conformity to justice, gives me another question in turn, which was raised for you by Mr. Ernest Slagg, or Slagg, of Burlingame. And Mr. Slagg asks you, first, whether there exist human rights which are really universal, inherent, and natural, in terms of which a just and consistent body of positive laws can be developed, or whether rights must always be arbitrary and merely expedient in the society which acknowledges them.
Again, I am compelled to say, Mr. Slagg, that there are 2 points of view here, 2 absolutely conflicting points of view. Some men suppose that all rights are legal rights. So like I said before, that all the rights that men have are granted to them by the state under its laws, and the state is in a position to take them away, just as it grants them, it can take them away. The opposite point of view affirms that there are natural rights, rights that are unalienable, that are neither granted by the state initially, nor can be taken away by the state. In fact, according to this point of view, that state is most just whose laws do acknowledge all the natural rights, and that state is unjust whose laws violate natural rights. But it must not be supposed that at any given time we have perfect knowledge of what the natural rights are. At one time, for example, it was not thought that slavery violated natural rights. Now we know that slavery does violate natural rights. One time, the rights of labor were unknown. Now we know that labor has certain natural rights which laws must not violate. I say this raises the whole question, which we can't go into any further this afternoon, about the growth of our knowledge and understanding of what natural rights are, which probably will go on till the end of time. Now this afternoon, as I see it, we have raised many difficult questions that we have not been able to answer fully, and even come to some that we haven't answered at all. Questions about natural rights and natural law, questions like the one I have here from Mr. Mooney that we can't even get around to, about what a man does with respect to obeying a law that is justly made in the sense it's made by constituted authorities, but unjust in substance, violating a natural right. Is he justified disobeying it, or should he obey it? This leads me to say something that I've wanted to say to all of you for many weeks. I hope that no one supposes these brief half-hour discussions of the great ideas do more than skim the surface. I must confess to you that I always feel somewhat dissatisfied at the end of a half hour, and frankly, I hope you feel dissatisfied also, because that's the right way to feel. It's the kind of feeling that calls for more and more discussions of the great ideas, of these fundamentals that can't be dealt with simply once and for all. Today in particular, we have had to touch on two great ideas in addition to the idea of law, the idea of justice and the idea of rights, particularly natural rights. And both of these deserve a whole series of discussions by themselves, which I hope we shall be able to do somewhat later. But I have decided to shift next week to a quite different subject. I hope that you'll be interested in it, the great idea of art. Our next series will be on the great idea of art, and I'm going to begin with the meaning of art in human life and try to show you the sense in which every man is an artist, and must be. Then in succession, I want to deal with the kinds of art, the nature of the fine arts, and aesthetic and moral problems in connection with the fine arts. I hope you have questions about art in general, about any aspect of human art, that you will send them in so that we can carry on the discussion in terms of your inquiries. Thank you very much.